Hello, and welcome to episode 12 of Counting on Law. For those of us who are fans of legal drama, season number 2 of Mamla Legal had just dropped on Netflix. Episode number 6 is called Act of God. Kuwait, Qatar, and Bahrain have invoked force majeure on all their oil contracts because of the ongoing war in Iran. Now, these are not terms that are foreign to us. Anyone who has entered a contract knows that force majeure clauses and their subset acts of God are standard protections within a contractual framework. It literally translates to a superior force. Force majeure means that in case any party to a contract is unable to perform their side of the promise because of a force that was beyond their control, then they can be excused for such non-performance. What are examples? Think of earthquakes or tsunamis or the Ebola virus or a debilitating war. Since presently the war in the Middle East has captured all our imagination, we decided at the Prophecy to look at instances from Bombay, Delhi, and NCLT disputes where force majeure was invoked as a major argument for escaping non-performance. We ask 3 specific questions. A. How many times is this invoked every year? What is the frequency of invocation of force majeure? 2. If force majeure is invoked in a contract, then what is it really invoked for? What is such a superior force that prevents people from performing their part of the bargain? And 3. If at all it is invoked, how well does this argument fare in court? Coming to the first question, force majeure is best understood as a lagged indicator of a macroeconomic event or crisis. Take, for example, the largest events that happened in the past decade, COVID-19. While COVID peaked in 2020 and 2021, its reflection on litigation peaked in 2022. Force majeure cases, which were otherwise averaging around 15 to 20 cases per 10,000 matters in these courts, suddenly had a spike up to 53 cases for every 10,000 cases in these courts. A few examples would be how some corporate debtors brought their matters to the NCLT, saying action against them should not be admitted because it was COVID-19 that prevented them from paying up their debts on time, or some other cases where people challenged arbitration awards saying the tribunal failed to consider the force majeure event of the pandemic. Several such events that began in 2020 and 2021 continued till date in these courts. But other than that, what are the major reasons why force majeure is actually invoked in court? And this brings us to question number 2. We saw that the pandemic is a major reason. Our assumption in legal knowledge and popular wisdom would tell us that wars and natural calamities are the very reasons for which we must insure our contracts with a force majeure clause. However, natural calamities or acts of God are less than 10% of actual invocations of force majeure. What about wars? Less than 6% of the matters actually cite wars as a reason as to why they wish to invoke force majeure. Sporadic mention of the US withdrawal from Afghanistan and the Taliban takeover, some mention of the Yemen crisis, and rarely ever a mention of the Russia-Ukraine war. However, then what constitutes the majority of cases where force majeure is invoked, but is not, say, the pandemic or these wars or natural calamities? These are instead acts of the state or regulatory actions that are so erratic and so unpredictable that they have prevented parties from performing their side of the contract. While the pandemic was about 30% of all force majeure invocations, about 25% or 1 in every 4 instances where parties come to the court and say that they have not been able to perform their side of the promise, it is because the state has done something that has prevented them from doing so. The range of instances spread on a spectrum from RBI's control of foreign remittances under the FEMA regime all the way down to how CIDCO has managed fire safety norms here in Navi Mumbai. In other words, regulatory changes are more frequent extraneous changes to contractual circumstances than real wars or calamities are. Now, if that wasn't concerning enough, how well do these arguments fare in court? Data tells us that if you were banking on force majeure as your major argument in a dispute in front of the court, then chances are the court is going to rule against you. In fact, in more than 70% of the matters, when across all 3 forums, force majeure was brought up as a major argument for escaping performance, the court has ruled against it. Arguments that rarely win are ones where they show direct causality between the force majeure event and the non-performance and are able to convince the court that they were put in an impossible situation because of the force majeure circumstance. More often than not, this is not possible, and therefore chances of victory are rare. But it is surprising to know that the greatest pandemic of the century, COVID-19, has a 22% chance of succeeding in court as a force majeure argument. However, if you were to bring up regulatory change as your argument for force majeure, you have a 25% chance of succeeding. In other words, the courts seem to concede that the regulator or the state is a greater erratic and unpredictable extraneous force upon your contract than even the greatest pandemic in our lifetimes. And therefore, what do we learn from this? A. Acts of the state have hijacked acts of God as the major reason for force majeure these days. For states that are rushing to better their ease of doing business rankings and bettering their investment climate, it matters as much that your policy changes are predictable as you focus on deregulation. The importance of collaboration, communication, and consultation with market players cannot be overstated. B. For those of us who are living through this war, we must realize that the court's docket today is a reflection of the world's problems as it stood a couple of years ago, and therefore we must brace for impact in the years to come for the fallout of the crisis in the Middle East. And C, for those of us who are entering into contractual obligations today, we must realize with a low success percentage of 25 to 30% in force majeure invocations that general catch-all force majeure clauses do not work anymore. If we want to insulate ourselves against the shocks of the war and of natural calamities, and most of all, against the regulator's unpredictable action, we must be specific in terms of what force majeure events can really affect our contract. To close off, the superior force that is going to strike your contract is much less likely a war or a pandemic, but most possibly the stroke of a regulator's pen. Brace for impact. Thank you.